welcome to our second Reconnect virtual roundtable and our fall 2020 webinar series entitled The State of the European Union, Reconnecting to European Citizens. As you can see, our lineup is not complete, and unfortunately one of our speakers has not been able to join us, Professor Petra Bard. Perhaps she will be able to join us a little later. But in any case, with us today are two experts on EU politics who will discuss the questions that this webinar focuses on, which are: did the speech by Commissioner von der Leyen live up to the expectations and the moment's challenges? Will the proposed plans help strengthen democracy and the rule of law in the EU? And do they help bridge the gap between the EU and its citizens by matching their concerns? With us is Professor Sten van Hekke, Associate Professor for Comparative Politics at the Faculty of Social Sciences at the University of Leuven, as well as Carolina Brescia, who is Associate Professor at the University of Vienna and an expert on public opinion and voting behavior, as well as a member of the RECONNECT project. In the latter part of the webinar, we will take questions from the audience as always, so please write to me through the webinar chat box to send your questions, which I will then relay to our speakers. It's now my pleasure to give the floor to Professor Steven van Hekke.
Okay, thank you very much, Alex. Good afternoon, everyone. First of all, congratulations with organizing this webinar, and thank you for having me. I'm very happy to kick off our afternoon session about the State of the Union 2020. My assessment overall, so this is the spoiler, is rather positive, but let me also start with a phrase I often tell to my students: low expectations are easily satisfied. I think it certainly applies to a State of the Union after elections and after a commission that is in place. Why would politicians bother once they are in office with no prospect, at least no immediate prospect, of reconnecting to European citizens? This is the least of their concern. So as far as democracy is concerned, next to the rule of law, my expectations were very low as far as the State of the Union is concerned, and therefore satisfied. They all were satisfied because we all know, of course, that the state of democracy would have been the #1 issue if it would not have been COVID-19, since we know that normally on Europe Day, the 9th of May, the conference on the future of Europe should have started. It would have been busy, as well as in Brussels as in different capitals and maybe small villages with agora talks and everything. This has been postponed, so there is not to blame the European Commission. Someone or something else is to blame here, but I think it will come back anyway in the next State of the Unions of Ursula von der Leyen. But it was clearly no hard feelings, not an issue. The state of democracy, elections, Spitzenkandidaten, how to reconcile the public with the EU institutions and policymaking, it was not at the agenda for 2020, and I'm fine. Even though I'm a political scientist, I have to admit that that's, at least for this year, I'm very happy to please my colleagues in the law faculties all over the world, so to say, that the rule of law, for good reasons, was one of the central issues, I think, of the State of the Union. The State of the Union has become a kind of a ritual. We all know it's US based, the origins are there, but COVID-19 did not affect it, even though not half of the people could attend it. I think the Commission is always very eager to develop something and to create a lot of buzz. I think reasonably this was a success. I also think it was pretty well organized, not too much, that they should not complain about the coverage, etc. So, and everything as in the digital age and as far as the EU level is concerned one can easily see, read, watch everything again on a special webpage on the website of the European Commission. So also in terms of research and reflection for students, for scholars, I think this is very helpful. And it was also helpful for me to have a look again. Of course, I watched it live on that Wednesday morning, 16th of September, to have a look again at the State of the Union, which is, of course, only a speech, and also probably for practitioners and policy making, even more important, the letter of intent. But I'm sure we will come back to that issue in the course of this webinar. My immediately takeaway messages that I was writing during the State of the Union is on the next slide. So we can use it this afternoon as a kind of a recap of what were the main issues, at least in my understanding, of the State of the Union. It was the 9th, so it's relatively young initiative, the first in Brussels. Strasbourg was another option again because of Corona, but only the first of President von der Leyen. It's an annual event, but it never takes place in an election year, because then the Commission is still being composed. And there are other occasions in election years, the first speech of the President-elect, the speech when the college has to be voted in the European Parliament, and other. So there is no lack of understanding what the Commission has in mind, but at least strictly speaking, the State of the European Union, it was the first of 4 in the term. Probably there will be a second term for von der Leyen, but at least it was the first of the 4 in this legislature. I think the start of her speech was very good, referring, of course, to COVID-19 and using the terms vitality and fragility. It was interesting to see that she suggested to discuss the non-EU competence of health, so to say, to discuss the fact that it's non-existent as an area of competence in the forthcoming conference on the future of Europe. There was a large focus on the social aspects of the market economy, as well as everything that is green. This was, of course, in line with her overall agenda. Then also a lot about the digital agenda. She said it in German, which was interesting. I think this was also a message to all kind of German companies, which she expects to be the new European tech giants. And of course, the term sovereignty also refers to the rhetorics, the framing, so to say, the narrative, if you want, of Emmanuel and Macron, how Europe should reconquer its position vis-à-vis the rest of the world, but also making it more legitimate vis-à-vis its own citizens. And then it changed, surprisingly, half of the speech, so the second part of the speech, was broadly speaking about the rule of law, because she raised foreign affairs issues from the perspective of the state of democracy and rule of law, and with a special emphasis on human rights. We are not surprised that the EU is very strong in declarations about human rights and the rule of law. I was much more surprised that it was half of the speech of the President of the European Commission, because after all, one could wonder if foreign policy is really an area in which the European Commission is competent after all. So I was surprised that there was a lot of attention as far as the rule of law is concerned in the area of foreign affairs. And I was even more surprised that Ursula von der Leyen was very explicit. It was an exercise in naming and shaming, especially as far as third countries is concerned. So she repeated what is in the meantime kind of a common phrase. China is an ally and a partner, but in terms of political systems, so referring to democracy, human rights, rule of law, it is a systemic rival. This is not a surprise, but it's a surprise that she put it in her State of the Union and that she was very explicit, at least in my understanding. She continued with blaming their own member states. Sorry, trying to be a bit more, or at least if you blame the others, then you should also take care of your own pupils, so to say, even referring implicitly to Carnival here in Aalst in Belgium and anti-Semitism. But of course, the usual suspects were Hungary and Poland. I'm sure we'll come back to that in the course of the webinar. Also referring obviously to the case of Belarus, to Russia, Magnitsky Act. Perhaps we should also have a Navalny Act in the EU, Turkey, and then also in the same way attacking, well, implicitly but almost explicitly, the way the US and the UK behaves in foreign affairs and how it affects the future, the new developing relationship with the EU. Migration, from a certain point of view, is also a human rights, democracy, rule of law issue, broadly speaking. So it was clear what her point of view was, and also that she really wanted to have a breakthrough in this long-lasting dossier, perhaps not dating back to the summer of 2015, but at least to the failure of June 2018, when the European Council was did not agree on the new package, and not much has happened in the meantime. She advanced the presentation of the new package on migration with 1 week, so that was presented 2 weeks ago. And then also again, within the EU itself, very strong on racism, LGBTQI rights, but also the rule of law, and presenting the new mechanisms that are in place. And that leads me to my third and last slides. What about the rule of law as an issue in the State of the Union 2020 by Ursula von der Leyen? One should be clear, it did not entirely fall out of the blue. It is not a new idea that there should be a systematic review of the rule of law and the quality of democracy, human rights, etc. in the member states. This is already an idea that has been floating before the elections of 2019. The Germans were one of the first to put this on the agenda. I think there we have seen in the last 1 to 2 years a growing consensus that we should get away from again and again attacking Budapest and Warsaw, that also in other member states problems should be tackled, should be defined, should be named, shamed perhaps, and that something should be done. If we still, as the EU, have the ambition not only to have the rule of law as one of the binding founding principles, but also to continue to teach lessons all over the world. It's the one that does not go, that should go with the other. So in that way, I'm not really as surprised. And I was not entirely happy as a Belgian political scientist with the nomination of Didier Reynders as commissioner in charge, but at least one should admit that he also was in favor of the systematic review of the rule of law, even long before his name was mentioned as commissioner, let alone commissioner in charge of the justice portfolio. That are elements of continuity. Elements of change were also there. I already mentioned to the fact that it was even more explicit, blaming other member states within and outside of the EU, and also that a large part of the State of the Union, I think this was the first time that a large part of the State of the Union had the rule of law as a general topic, broadly speaking. What is to expect? I think the European Commission has already a track record in mainstreaming certain ideas. So it launches something and everyone thinks, well, okay, it's another idea and it's nice to have visuals and a nice PR campaign. They're very well, but after a while one finds that these ideas are popping up in all kind of different areas. So I think my hypothesis would be that the same will happen with the rule of law. That, for instance, within calls of scientific research, even more money than today will go to ideas, projects in terms of rule of law. So I think there is certainly a future, a promising future for the Reconnect network, so to say. The most difficult issue, as we all know, is of course the issue of conditionality. How can you force member states? How can you try to steer third countries in the direction of a better application of the rule of law? We all have seen the discussion of the last couple of weeks and days. It will not be easy. The parliament is, of course, very important in this, but let's see what will come up and how the Visegrad 4, because of course we are first of all thinking about them, will deal with this issue of coupling the MFF with application of the rule of law. Implementation is also something that we should be critical of. It's one thing to launch an annual review of the rule of law. And as a political scientist, I will never say that naming and shaming will not work. But at the end of the day, what matters is what is really changing for citizens within the EU and hopefully also citizens outside of the EU, if the EU is serious with coming up with proposals with more emphasis on the rule of law. That is, I think, the final litmus test. And perhaps the other question, which we were started, which is also the topic of the webinar, will it help to reconnect citizens with the EU to become more credible, to become more legitimate as policymakers vis-à-vis EU citizens? This you. I give the floor back to Alex.
Thank you so much, Stephen, for this insightful overview. I think we might have Professor Petrobard with us. Unfortunately, it seems that there have been some technical issues. I'm not sure if Petra, could you try to unmute yourself?
Hi, nice to hear you. I'm sorry, I'm having some technical difficulties to see you and to make myself visible. So I will give a final try, and then if I don't, what if I just give you my presentation without myself being visible?
That might be the easiest option. I'm happy to share it from my side, and we can hear you clearly. So that is indeed the main thing. And apologies for the technical.
No, I'm really sorry about that. It's you know, technology is the great enemy of good ideas, I always say. But I'm trying my best these kind of circumstances.
We can see you. We can't hear you. We can't hear you. Yes.
So thank God there are multiple computers in this family. I'm very sorry again, and I'm very happy to be with you after all, despite all the difficulties. And I just wanted to start my presentation with bumpy beginnings anyway, not technically, but what I wanted to share with you is that indeed the Commission had a bumpy start into this rule of law domain. So very high, but also very mixed expectations surrounded the speech of the Commission President on the state of the rule of law. Now, the expectations, I think, were huge because the defense of the rule of law is existential. It's an existential issue for the European Union. Violations of the rule of law in any member state is an EU matter. Should elections not be fair in a member state, we will end up with representatives in EU institutions that delegitimize the whole democratic process for all European citizens. Also, the EU claims that it's playing a pioneering role when it comes to third countries, exploitation of the rule of law and other values that are enshrined in Article 2 of the Treaty on the European Union. If it cannot take care of its own internal affairs, then the EU will seem hypocritical. Also, if there are no disincentives attached to rule of law backsliding, this phenomenon may just become contagious. As we say, one rotten apple spoils the whole barrel. And once the values are not respected, the essential presumptions behind the core of union law do not hold anymore. You need the rule of law, for example, the independence of judiciary for an investment-friendly climate. You need independent judges for the functioning of the single market. You need them also for a well-functioning asylum system and criminal law system. To give you a very vivid example now, courts in Amsterdam and in Karlsruhe refused to surrender suspects to Poland, strictly speaking, in violation of EU law, in fear of becoming complicit in human rights, especially fair trial violations. If these people, if these suspects are tried by courts that are no longer independent. But not only were the expectations high, they were also mixed due to the bumpy start of the Ursula von der Leyen Commission, as I indicated at the beginning. Many blamed her for being rather weak on the rule of law, especially in terms of rhetorics. I mean, of course, before her election, we couldn't say more about this. But still, she was voted in the end with the support of two autocratic governments, against whom Article 7.1 proceedings are currently pending. In her first interview ever given on rule of law matters, she tried to hit a reconciliatory tone, and we have already talked in partially this circle about this interview and these early beginnings, and she was already there very much criticized for belittling the problem, relativizing the problem, saying that nobody was perfect, instead of pointing to substantive rule of law issues. What is more, she also claimed that there were dividing lines between Eastern and Western member states of the European Union, and the views of the Eastern understanding of the rule of law were not respected by the Westerners. Now, this very much corresponds to a repeated criticism coming from Central Eastern European political forces with respect to the rule of law, who call this whole exercise of rule of law scrutiny a tool to advance a political agenda, a fiction, a magic word, I quote, blah, 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 unquote, a tool used by political migration forces along other vague concepts to weaken national sovereignty, or most recently, this is a means of political blackmail. Now, in more sophisticated terms, there is this East-West divide also invoked by these politicians, and this is one of the myths that we have actually debunked in one of our Reconnect papers. It's deliverable 7.1, if you wish to consult it, saying that there is no alternative European understanding of the rule of law, and these are academically simply dishonest attempts that are claimed that such a thing exists. Now, national differences, of course, do exist, but there is a crucial difference between a dialogue among constitutionalists within the framework of constitutional democracy and a dialogue of delegates of constitutional simulacrum, as Kovacs and others are claiming. So the Commission should recognize that these claims do not form parts of a multi-level constitutionalism and shall be deconstructed as just simple delusions, giving autocrats giving autocrats more time to complete constitutional capture. The Commission should also preferably make sure that these claims of having an alternative liberal concept of the rule of law cannot be used as a carte blanche authorization to override European Union law. Now, a part of these rhetorical challenges, there were also other issues in relation to the start of the von der Leyen Commission. For example, the baptizing of one of the portfolios, protecting our European way of life, saying that it normalizes hate mongering and xenophobia. Some others, they said that they blamed the Commission and especially the President for giving the portfolios to Article 7 violators that they wanted, and this was mainly problematic in relation to Hungary, which is now having a portfolio overseeing the rule of law, media freedom, corruption, and all the issues externally in countries that wish to join the European Union and neighboring countries that the Hungarian government itself does not respect. Now, let us turn to what the Commission did after all these rhetorical and rather political issues from a substantive point of view. Here, the Commission's communication on the state of play and possible next steps of April 2019 and the rule of law blueprint of July 2019 were very, very relevant, and they have so to say foretold what was coming. And here we can see already again a theme that the President was also following in her State of the Union speech, and this is the theme of dialogues. And this is not just President von der Leyen, but it's also her commissioners that are dealing with justice issues and rule of law issues. Also, Justice Commissioner Reinders, for example, emphasized that discussion is the key to problems. And he's also, of course, the mastermind behind the Belgian-German proposal for a periodic peer review on the rule of law in the EU, setting up an interactive discussion on an expert level in the General Affairs Council. Now, this discursive approach that is propagated by the Commission President and other commissioners is indeed it might indeed work very well with those member states who do speak the same language as the other party to the dialogue, so to say. But when it comes to the actual protection of the rule of law, here the Commission emphasizes, or the Commission, the President's speech emphasizes the external affairs and puts a much smaller emphasis on internal affairs. And when there is the internal affairs issue, when we look at the actual approach of the Commission, and not only on the level of talks, but in action, we will see that the Commission emphasized the need for promotion, prevention, and response. And here again, the Commission believes that the response prong is the least important, or at least that an emphasis should be placed on promotion and prevention of rule of law backsliding. This is very much reflected by the speech itself. Highlighting the importance of the rule of law. So I very much agree with you, Professor, saying that yes, there were important statements making clear that rule of law is a priority issue for the Commission. But talking about a starting point any rule of law backsliding is really a pretense that challenges in the European Union to the rule of law are novel. The president still seems to be convinced about the need to emphasize the prevention after a decade one of its member states and 5 years of backsliding in another member state and other member states following suit. The president talks about prevention in the year where Freedom House Nation in Transit reports proves that Hungary is no longer a democracy, and the report of the Varieties of Democracy project classifies Hungary as autocratic. Whichever index assessing subparts of the rule of law are consulted, whether it's the civil society organization sustainability index or an academic freedom index, this country is lagging behind, and there is a rapid decline that is diagnosed in all these indices. Most importantly, Article 7.1 proceedings are started against these countries. Against one of these countries, the Commission itself started an Article 7.1 procedure, and these don't seem to be mentioned. Then, now let me move from this part to the actual assessment of the rule of law and how it should function. The president is, of course, making a reference to this in the recently published annual rule of law reports 2020, and again in this relation, she says that the document is primarily there in order to have a starting point for discussions, for dialogues, and also in order to have for the EU a preventive tool. So again, we see the same terminology. And if we look at the document itself, then we will see very many pros and cons. The one advantage that I very much appreciate is that the Commission debunks this myth that the rule of law is something that you cannot grasp, this is too vague. On page 1, in the second paragraph, it actually gives also typographically a very much elevated way, a very clear, very short and very concise definition of the rule of law. What is also to be praised is that there is a regular assessment, and in line what the president was promising, this is treating the member states on an equal basis, not singling out one or another, which was clearly one of the disadvantages of the scattered patchwork nature of the use of rule of law monitoring and other mechanisms and enforcement mechanisms throughout the European Union in the past years. The selection of subject matters also makes the member states to some extent comparable, although this is not really the objective of the Commission, and I think this is methodologically also the correct way to proceed, not necessarily have these very strict legal comparison, but it indeed gives us a clear picture of where we Europeans currently stay with regard to democracy and the rule of law. On the minus side, when we actually check the documents, we can trace the same problems that are there from the beginning of the Ursula von der Leyen Commission, and for which the president is systematically and regularly criticized for. The one is that she, or the Commission, I'm sorry, rather fails to show the interrelated nature of rule of law issues in the member states. If you look at and I'm just singling out Poland and Hungary because these are the two states against which Article 7.1 procedures are pending, but I could also name others as well. But here, well, it's actually quite more complex in relation to Poland, so the reports give a more complex picture there, but in relation to Hungary, it simply fails to show that there is a systemic attacks on institutions that speak truth to power, so to say, that are criticizing the government. It simply fails to mention a number of issues, and it might not necessarily be the failure of the Commission. So the exercise started in 2020, and of course all we remember are the issues that happened in the past couple of years. But one of the most crucial things is, and I think this is emblematic of the problem, is that the capture of the Hungarian Constitutional Court is simply not mentioned. Now, if you do not mention the old stories that are there already in the Tavares report of 2013, then you will not grasp all other issues as well, such as, for example, that administrative bodies can now question final court judgments in front of the Hungarian Constitutional Court, which is not only a rule of law matter because it questions legal certainty, but it's also a rule of law matter because ultimately it's a captured institution which will have the final say in the matter. So this is an overarching problem, so to say, and finally the last problem that has already been mentioned, it's both in the speech and also in the document, in the annual rule of law report, very much visible. We don't know what would happen with this monitoring exercise. I mean, monitoring exercises we already had in the past. Really, the effectiveness of any Commission action hinges on the response prong. What do we do with these assessments? And here, of course, the big question is how conditionality, when assessing rule of law conditionality and the allocation of funds, would take this assessment or any other assessment into consideration. But of course, the Commission, well, this is now the big topic, but if I could have some recommendations of the Commission, I would say, let's not forget the traditional and old obligations that are stemming from the treaties, for example, in terms of launching infringement proceedings. If we look at systemic rule of law backsliding in the member states, so far, this proved to be the most efficient tool. And of course, this could also be reformed in a way to start systemic rule of law infringement proceedings, as, for example, propagated one of our scientific board members, Kimberly Chapley, right? Or we could also bundle cases, or as I recommended somewhere, all infringement proceedings with a rule of law element should be automatically prioritized, accelerated, and interim measures should be used. There is still potential for the European Commission, which in the past year started one single infringement procedure that was related to the rule of law, despite the fact that the member states gave ample possibilities for the Commission to start other proceedings as well. I stop here. Thank you very much.
Thank you so much, Petra, and thank you for overcoming the technical issues and joining us. And I would move on to Karolina Plesza without further ado, who will, let's say, give us a concrete idea of what citizen perspectives on the State of the Union address may be. So, Karolina, you have the floor.
I
will make you presenter in just a moment. There you are.
Okay, let me just. You should see now the full screen mode. Okay, excellent, good. So, well, hi everyone, from my side, and thank you, Alex, for the invitation, and thank you for Reconnect for organizing such an interesting discussion today. I was following the discussion very closely already, and what I want to do in my short presentation is to focus on probably what I know best is the sides of public opinion. And especially what I like to do is sort of like check with you the connection or the disconnection between some of the priorities or aspects that the President mentioned in the State of the Union address and those that we know are the concerns of citizens. And I will use some data collected by the European Commission in the Eurobarometer and the flash Eurobarometers in the past months or so. And of course, she naturally started her address with a focus on COVID. COVID is the priority, naturally. And what was interesting for me during her speech is the focus on not only COVID per se and the pandemic, but also how much the pandemic and the response to the pandemic needed coordinations among the European member states. And she stressed this word of coordination, trust, and confidence several times. And she also use this as an occasion to talk about the European Health Union, stress the need of a stronger union from the point of view of health coordination. And she definitely has citizens with her in terms of these aspects. If you see that the majority of EU citizens are so agree with the view that the EU should have more competences to deal with crises such as the corona crisis pandemic. So the view and the understanding that these are matters that the EU should deal at the EU level, cannot just be an action at the state level. And citizens also seems familiar with the measures that have been enacted in the past months, but only a relatively minority of citizens are satisfied with these measures. Of course, there are huge variations across countries, but you see that just about one every two citizens is satisfied with these measures. The focus has been also on solidarity, and it seems that a lot of citizens, especially in the countries that have been hit harder by the coronavirus crisis, they see the response and the solidarity response to have not been enough in the past months. But the picture is a little bit bittersweet. So on the one hand, a lot of citizens seems not to be satisfied with what the EU has done in the past months, but at the same time, the majority, the overwhelming majority of citizens want to strengthen European cooperation and European integration, especially from the point of view of health coordination. The other aspect that the president really stressed is the economy and jobs. She mentioned that as herself was the Ministry for Labor and Social Affairs in the German government, she knows how important these issues are. And she touched upon a very important aspect for citizens in a public opinion survey in June 2020, the data show that more than half of the respondents have experienced some personal financial difficulties in the past months. Of course, there is huge variation across countries. Only about 10% of the respondents in Denmark experience unemployment, partial or full unemployment, and these percentages are much higher in countries like Italy and Spain. But her focus on next generation EU, dignity, solidarity, and the minimum wage are at core concerns of European citizens. So she definitely touched upon some of these very important aspects for citizens. The other point that was stressed very much by the president during the State of the Union address is climate change. she spoke of building the world we want to live in, and made some very serious pledges in terms of climate change, in cutting greenhouse emissions, climate neutrality, and the budget in terms of how much the EU wants to spend in terms of climate change. And she definitely has citizens with her on that. The most recent data I could find in this regards in terms of public opinion is a survey, the special Eurobarometer in December 2019, where 76% of the Europeans respondents think that climate change is a very serious problem, and 31% says that this is an extremely serious problem. This is much higher, a percentage that is way higher than what we find in other countries like the US, etc. So, and what is interesting also is that the majority of respondents say that their government and the EU is not doing enough in terms of climate change. Of course, these data are from December 2019, so that's before the coronavirus. Things might have changed in terms of priority right now, but climate change is among the most important issues for European citizens, and she touched upon this aspect quite at length during her address. When it comes to the rule of law and corruption, here I tend to side with Petra on that, on what she said. So she did touch upon the rule of law, but very mildly, if I have to say my own opinion. There was no direct reference to Poland and Hungary, and this was criticized by multiple political factions. Also, if you think about how important the issue of corruption is for many European citizens, was a little bit surprising that she did not even discuss this issue in the State of the Union. There is an overwhelming majority of citizens that think that the rule of law and corruption is a serious issue in their country, and that this is a political issue that also reinforce that distrust and disconnection between citizens and politicians. So perhaps this was one of the points that she should have stressed more strongly in the State of the Union. She touched upon several more issues, of course, like digitalization, as was also mentioned by Professor Van Ecker at the beginning, globalizations and global affairs. She made references in this regard to human rights quite extensively, mentioning Belarus, China, migration as well, and this is migration is among the top priorities for European citizens. It was before, starting from 2015, and today now. But what we see here is a huge variations between the member states. So in the way citizens want their government and want the EU to behave, and I think this is a very contested issue, and this is probably why she didn't really talk that much about the migration issues this time. And for me, what was also interesting to see is that she did mention issues of racism and equality, mentioning hate speech, hate crime, and issues of identity and ideology. But she did not touch upon the aspect of gender equality, which is a critical issue for many European citizens. So I think overall the picture is bittersweet, in the sense that she touched upon several of the important issues for European citizens, but perhaps not in some cases, like the rule of law and migration, not at the level that some of the citizens might have wanted to hear from the State of the Union. And this is all from me, and I'm happy to take questions on the aspects I've been touching upon during my presentation. Thank you.
Thank you so much, Carolina, for this I think very interesting overview of how the speech relates to what citizens care about, which is of course one of the key issues we're interested in our project. Perhaps before, we already have a couple of questions from our audience, but perhaps I could ask Professor Steven van Hekke if he would like to elaborate a little on what he means by the fact that our expectations, or his expectations anyway, were quite low when it comes to the speech in general and specifically on the rule of law. Perhaps I can just reiterate a couple of the things that were mentioned about how Hungary, of course, is not classed as a democracy anymore by Freedom House, and in many ways the principles that are at stake are very much kind of at the heart of let's say the existence of the European Union itself. So perhaps you could elaborate a little bit on that. And instead, when it comes to Petra, kind of playing devil's advocate, I was wondering, well, on the other hand, it could be argued that this is very much, so to speak, a kind of a political commission in action, which has, of course, its negative sides, but on the other hand, the EU is indeed extremely, well, quite diverse, also from kind of from a perspective of constitutional understandings of how states should function. So perhaps we shouldn't be so surprised that von der Leyen was soft, so to speak, towards some of these member states. And to Caroline instead, I was reflecting on when you were providing these statistics on fundamentally what would be your assessment of what citizens care about. And this, I'm thinking also of issues such as citizen engagement, which is something that perhaps we would have expected to be very much at the heart of the speech, but was not. Thinking, for example, on the conference of the future of Europe. And so would you say that citizens are more focusing on whether the EU is kind of delivering also when it comes to moments of crisis such as COVID-19, or are they also interested in kind of engaging on issues of more process, let's say, and kind of throughput democracy, as some would say, which is interesting from a perspective of kind of policy recommendations from our side. Perhaps Stephen, you would like to begin?
Yes, thank you, Alex. Also, thank you for the colleagues for the stimulating thoughts about the State of the Union and the state of the rule of law. Why were my expectations rather low? And from that perspective, I was happily satisfied or surprisingly satisfied, which is of course a different perspective than from the citizens' preferences per se. So it was more, let me say, Brussels bubble with an academic source perspective. Why I was positively surprised, because it's after all not a usual topic of the State of the European Union. So I didn't do research myself, but I supervise a number of the best master thesis students. The KU Leuven certainly has digging into the State of the European Union, and it raises, of course, a lot of issues. But in my understanding, the rule of law is not even in the top 10. So from that point of view, I think it's surprising still. A second reason why my expectations were very low is because, of course, everyone expected, for good reasons, to be the COVID-19 speech, which it was in partial, at least the beginning, but certainly not the whole speech. COVID-19 was more used as a pretext, I think, to raise a number of other issues. Also there, never underestimate the European Commission. We have seen that before. European Commission is very eager to develop its agenda. Think about the MFF, think about socio-economic affairs, and they use COVID-19 to raise the sense of urgency. But at the same time, it was not played really that way. There was no clear link with, for instance, how COVID-19 was abused, misused in Budapest to even further limit the freedoms of journalists, of academics, etc. But that would not have been that would neither be a surprise. The first reason why I was surprised is that, after all, the narrative that the European Commission was successfully trying to sell last year is that it was a geopolitical commission. So the foreign affairs perspective was very clear, but it was based on interests. What is in for us? We want to be also on the world map, not only as a go-between between Donald Trump, US on the one side, and Xi Jinping, China on the other side. We want to have our own big tech companies. We want to have our own agenda. So I don't blame them. But it was an interest-based geopolitical commission. Now I think it was more value-based. Of course, this is a black and white and distinction, I know, but just to put things a bit in perspective, I think the geopolitical dimension was still there. It was not explicitly mentioned, but it was more value-driven this year compared to last year. I think last year, strictly speaking, it was not the State of the Union I already referred to, but the July speech as well as the November speech was much more interest-driven compared to the one of this year. That makes up for me 3 reasons why I was surprised that the rule of law had such an importance in this State of the Union. Thank you.
Thank you, Stephen. Petra?
Shall I? Thank you very much for the questions. Yes, we shouldn't be surprised. I very much agree with you, Alex. I am not, but not in a good way. So I accepted this coming, but this didn't meet my expectations as a European citizen. I understand that the Commission claims to be, and this is not a recent thing, to be a political commission. And thank you for raising this issue, because this is vital also from a rule of law perspective. The fact that it's a political commission does not do good to the exercise of rule of law monitoring and rule of law enforcement. So in this regard, I very much appreciate the efforts of the European Parliament, for example, which is very much pushing for a democracy, rule of law and fundamental rights pact that should monitor also regularly on objective and equal basis the member states' health status from these perspectives, but not with the Commission at the core of the exercise, but with an independent body, however we put together this body. But in any case, an independent and an independent looking body at the core of the exercise, because those member states which will be criticized and criticized harshly, and it already happened with regard to the 2020 annual rule of law report. So these countries harshly criticized will be in a difficult position to counter the criticism. And if they cannot counter the criticism, they will attack the critique. And if the critique is a political and self-admittedly a political commission, then they will be blamed for turning a normally legal matter into a political one. And this is already very much happening at the rhetorical level. For example, the Justice Minister of Hungary saying that this is nothing more but a political attack on some Western states to push through some ideologies in Hungary that do not correspond to the will of the nation and do not correspond to the interest of the Hungarians either. So I would dispel again this other myth that this was a political issue, and there the fact that the Commission declares itself to be political is not beneficial. It's another thing, as you rightly said, that or it has previously been mentioned, that now the von der Leyen Commission tries to reframe itself as a geopolitical commission. And finally, however the Commission characterizes itself, in the end of the day, the Commission is the executive of the European Union, the primary obligation of which is to oversee the treaties and to enforce the treaties. And I think whatever new instruments we adopt, in the end of the day, the Commission is obliged to uphold the treaties, and of course, it's a very technical answer to your question. You know, this is what the treaties say, this is what it has to do. But we also have to acknowledge that this is existential for the European Union itself, as I said at the beginning. If there is no rule of law, if there is no judicial independence, then European Union legal concepts such as direct effect or even the supremacy, the primacy of EU law doesn't hold anymore. And this is really the end of EU law and the whole European project, I'm afraid.
Carolina, and thank you to Petra.
Thank you, Alex, for your question. The role of the EU has tremendously changed in the last 20 or 30 years. And in parallel to more and more powers given to the EU, there has been this process of contestation and politicization at the EU level, at the citizens level. And this is also what we find in Reconnect through our data collection, is that a lot of people talk about the EU and are increasingly more informed about what happened at the EU level. So before, the public was there, but was a kind of like a dormant entity. Instead, right now, it's no longer like this. And I agree with Petra, is an existential threat for the EU, also from the point of view of its citizens, and the Conference of the Future of Europe also wants to bring citizens in the process much more. So not only citizens are called upon every 4 years or 5 years at election time, but more involved in the policy making process, exactly to address this concern of a democratic deficit. And what we see also from the data, I've shown some of them today, is that citizens are aware of what the EU does. They want the EU to have a role, but a role that brings them, first of all, advantages, economic advantages, security, coordination, and in the case of COVID, also health coordination. And I think we have the basis now to have the citizens more involved. This is difficult. I'm not saying that this is easy. It's very difficult, but perhaps it is really the time to do it. Because citizens seems to be they want to be involved, they want to be engaged. And I think if you think about the little experiments that we have in the different countries, like think Ireland, where citizens, ordinary citizens meet in assemblies and discuss policy making procedures and changes to electoral rules, etc. I think this can be done at the EU level as well. With time, as I said, it's not easy, but it's a challenge that the EU should try to take on.
Thank you, Carolina. And I think we can move to a couple of questions from the audience. There's one that I would directly address to Petra, but of course anyone may jump in. I heard much of the DG research budgets would be directed towards biosciences and the development of vaccines. Whilst this may be considered as a side issue, it seems to me the support of researchers on human rights issues should not deserve less attention, especially since they play a huge role in rule of law, in dealing with rule of law related concerns. And so on and so forth. And this is from Patrick de Bouquois. And then we have kind of a more general remark that plays into another issue that I was meaning to touch upon, and that is looking at the speech, but also looking at what will happen in the aftermath of the speech, the consequences of COVID-19. The President of the European Commission focused on two areas that needed, that she argued needed strengthening and developing. On the one hand, a European health union, and on the other, foreign policy. There's been talk, of course, of introducing qualified majority voting in that area. So areas essentially where the EU lacks competence. And we have a more concrete question from Priya Pujari: how likely is that this will actually come to pass? How can this be achieved without indeed strengthening the interinstitutional mechanism within the EU, and in particular without empowering further the European Parliament? And then there is a specific question for Carolina, who is asked again by Priya Pujari: what are the citizens' takes on President von der Leyen's health union? So again, health competences. In previous evidence presented by RECONNECT, we saw that country ratings on the issues showed that citizens were giving greater importance to health policy in certain countries. And how will this be received by citizens from looking at the evidence that we have already in the context of RECONNECT? Who would like to start to respond? Back to you, Stephen, or Petra?
Fine, but I'm not so sure about one question. Where does the EU lacks competence, in general or as far as the rule of law is concerned? In general, it sounds like my wish list. Not sure if the audience is interested in that. If it's really related to the rule of law, I happily to pass the floor to Petra. I think, Petra, you're more into this topic. What is really needed in terms of then treaty change in a way to strengthen the position of the EU in general and the Commission in a particular as far as enforcing the rule of law?
Okay, shall I take over at this point? Yes, of course, happily. Okay, then I start with this question. You know, is the EU lacking competence, or is the Commission lacking competence to do something about rule of law backsliding? I would argue that it does not. Of course, we have suggestions, and actually in the framework of RECONNECT in the package 15, we will summarize possible treaty changes and changes to the Charter of Fundamental Rights, which would enhance the enforcement of the rule of law and other values enshrined in Article 2 of the Treaty on the European Union. But I would argue that this exercise, even though it may bring benefits, is not necessary. The EU does have the competence to intervene when it comes to rule of law backsliding. It has the obligation, I think, to intervene, and it also has the tools. It has the legal tools to do so. Some tools are more advantageous and beneficial than the others. For example, there is Article 7, which is said to be the nuclear option. Oftentimes in the literature, fortunately now this denomination is abandoned by scholars and journalists too, because this really isn't a nuclear option. Article 7.1 is there to conduct a dialogue. It doesn't have a sanctioning prong. So we could make more use of Article 7.1 and at a much earlier stage. So technically, Article 7.1 procedures have been opened thus far against member states when Article 7.2 procedures should have been opened. In other words, when there was no threat of a systemic breach of the rule of law, but it already happened. Constitutional capture already happened. Then, of course, there is Article 7.2 and 7.3. I discussed them jointly because these are there for the determination for an already existing rule of law, systemic rule of law violation, and one could attach sanctions to this. These have never been used and probably will never be used because of the high threshold. So this is a high political threshold for the procedure to come to an end. So probably this is one of the instances when a treaty change would be beneficial for the whole exercise. And once sanctions should be imposed, here again, the European Union could be very creative, because it's not just about suspending the voting rights in the Council, as often claimed, but it's basically the suspension of some other rights flowing from the treaties, and we could think of what these rights are and how to suspend them. And then there is this other other quasi Article 7 procedure, which is referenced in the literature as a pre-Article 7 procedure, the rule of law framework. We have seen that it really doesn't work very well. It has been launched once in EU history against Poland because of a violation of the independence of the Polish Constitutional Tribunal. And again, let me refer back to my original speech here. The emphasis was on dialogue. The Commission gave more and more recommendations and extended the deadlines given to the Polish government again and again. And even before the procedure would have come to an end, the independence of the Polish Constitutional Tribunal was unfortunately already gone. So this is not a very useful exercise. I would simply abandon this. Where we can see potentials is really infringement procedures, especially if the Commission could pinpoint the systemic nature of rule of law violations. It would be very, very beneficial. Another proposal of mine is to call a spade a spade. In other words, if this is a rule of law violation that we are facing in the framework of an infringement procedure, this should be named a rule of law violation. And here I'm obviously referring to the forced retirement of Hungarian judges, whose case was framed by the Commission as an age discrimination case. And this was a crucial mistake, because in discrimination cases, the remedy is compensation. And this is what eventually happened. The individual judges got compensation, and the story was mute, and the case was moot. But if the case is construed as a rule of law violation, as a violation of judicial independence, then of course you have to reinstate the judges in order to restore the rule of law in the given country. So call a spade in these infringement procedures. As I said, if there is one lesson to be learned from the past 10 years of rule of law backsliding, it's that time is the best friend of autocrats. So they just accelerate these procedures and use interim measures in order to put a halt to all efforts of constitutional captures, because once the capture already happened, it will be very difficult to take a U-turn, or in other words, later will be too late. And then there are also the preliminary references which can be made use of even currently. The only problem with these preliminary rulings is that its implementation mainly depends on the national courts, and if the national courts are captured, then it will not fully happen. But we see that especially in mutual trust cases, and I also made reference to these criminal cases where people are, for example, not surrendered to other countries because of a fear that the prison conditions are so heinous, or they won't be given a free trial because the courts are not independent. So these preliminary about European citizens. These seem to be very abstract concepts, but in the end of the day, there will be an individual whose human rights will be violated. And the court cannot engage in academic discussions. The courts have to put an immediate end to possible human rights violations. And this is what eventually will happen. But I would argue that currently, especially in these criminal cases, there is too much of of a pressure on the courts. So the courts should not take the full liability for suspending EU legal concepts. If the Parliament and the Council pass a piece of legislation on the presumption that every member state is a state on the basis on the rule of law, based on the rule of law, and it's a state that respects human rights, and if this presumption is rebutted, then the Parliament and the Council and also the Commission should take responsibility for suspending such a legal instrument. And this is what the Pact for Democracy, the Rule of Law and Fundamental Rights would satisfy if this was adopted. So currently there is an ongoing debate about an interinstitutional agreement on this pact. The Parliament trying to tie in the other two main institutions to cooperate in this exercise, which would be very, very beneficial, because really the rule of law is not a political issue, but the enforcement of the rule of law and the suspension of laws that EU institutions have passed is a political issue for which political responsibility should be taken, and you cannot shift this whole liability to national and EU courts. So all in all, what I'm saying is that yes, we do have the necessary tools and the lack of willingness on the side of institutions and some member states to use them. I'm sorry, there were other questions, but I don't want to dominate the debate, so maybe I come back to them.
Thank you, Petra, for your always extremely informative and insightful overviews, and especially when it comes to the rule of law. Perhaps I should clarify one of the questions, which again related to an issue of EU or lack of EU competence, which was specifically when it comes to health policy and foreign policy. So when it comes to the European Health Union, of course, it's something that was triggered by the COVID-19. And there are, of course, other geopolitical pressures that have instead driven, pushed, let's say, foreign policy higher on the EU's agenda. And we've seen this reflected also in the speech. And so the question was, looking beyond the speech, concretely, how could this happen? Would it happen through also a further empowering of the European Parliament in these areas, and whether at all it is likely to happen? And perhaps Stephen and Carolina can share their thoughts on this.
If it's okay, I can just would like to mention something about a health issue, because this is something we also investigated and examined within RECONNECT, because, and it's interesting perhaps to point out the fact that it seems that the majority of citizens, and this is before the Corona crisis, they all, like the majority of them, wanted the health issue to be a national competence area. So they would prefer to have the health issue to be dealt at the national level, not at the European level. This was in May 2019. Now, what has changed dramatically is the realization that when you have a pandemic, then the pandemic does not recognize the national borders. And so what we have noticed, the similar respondent asked about a year after, all agreed that the EU should have far larger competences in the health issue area as a policy to deal with such crisis. And I think what was mentioned in the State of the Union address is really about being having a stronger European health union to deal with these issues. And so on the one hand, broadly speaking, it seems that citizens want the health to be a national competence, so the national government, and this is especially true where citizens perceive the national health system to work well. So they want to keep it as a national level competence, but obviously the crisis poses completely different types of challenges that must be dealt at the European level. And so this means, of course, giving more competence at the European level in dealing with this. If this should be just extraordinary measure rather than ordinary measure, this is the question. And it seems that the citizens want this to be only an extraordinary measure rather than having it dealt at the EU level all the time, at least reading the data. That's what this data seems to suggest.
Yes, maybe I can jump on that. I think I largely agree with what Carolina said. The analysis, I think, is quite right. The European Parliament is also always in the front row to ask for more competences, so that should not be a surprise. The surprise is rather that it's not heard so explicitly as far as health issues is concerned. So not even Guy Verhofstadt is holding a plea that the EU should run the hospitals in Bergamo. And I don't think even the Italians would be in a favor, or the people of Madrid. So this is not on the table. I think indeed cross-border issues, this has always been the strength, and it even relates to the single market. You can even talk about doctors and nursing crossing the borders if you don't care about patients. At least COVID-19, the patients are the center, should be the center of our attention. But even if you don't take them into account, there are certain cross-border issues indeed that came to the front in this crisis that need to be helped with urgently from a Belgian point of view. Also, I would like to see, from a personal point of view, see the European Commission and also the Parliament acting more strongly. I think, for instance, it's a disgrace that Belgium, which often sees itself as the champion of EU integration, did not take any patient from another member state in the heat of the crisis, February, March, April. This should not happen again, and therefore I count on the EU institutions. Pity us rather than Belgian politicians. This is what is really at stake. So solving cross-border issues in health competence to make clear that solidarity among member states, among patients, those who are in the most need, who are risking their lives, fighting for their life, should be able to count on the EU. Thank you.
Thank you, Stephen. And on there was also the second part of the question on qualified majority voting in foreign policy. Stephen, would you like to add anything on that?
Yes, let's switch positions. Alex, I'll be the moderator because this is more your topic. It's an ongoing issue. I think it will take another couple of years, maybe legislators, but we are moving very, very, very slowly. And at least thanks to the brave people in Belarus, it's now on the table that qualified majority voting should be installed in foreign affairs as far as sanction is concerned. It's a big issue for the people involved. It's a small issue for the EU because there's a lot still in the foreign affairs area, but at least the direction is clear. The tempo one can discuss. That would be my answer as a non-expert.
Thank you, Stephen, for addressing that point. And perhaps we have one final very quick question from Marcel von Colani, who says, would you agree that the increasing tension between the role of the Commission as the guardian of the treaties and its intention to be a more political body should be resolved by separating the two functions into different bodies? If so, how could such a new institutional setup look like? Perhaps a difficult question to close on, but
no, but I think it's a very important question. It might be the agenda for forthcoming webinars or thinking within Reconnect, or generally speaking. I think this is an unresolved issue in the EU institutional architecture. Also, for instance, competition policy. In fact, this should be an agency. There should not be a member of the European Commission. If the European Commission wants to be political, then you cannot have a commissioner in charge of competition policy at the same time. I'm not so sure whether it also applies to the rule of law. That's maybe a question for Petra, whether there is really a conflict, not of interest, but of role. Because after all, I think imposing the rule of law is much more political than something like competition policy, but it's certainly something to think about. And I really like the answer, which is not like the question, which is not easily answered. Thank you very much for that. It's a nice closure almost of this webinar, I think.
Yeah, I would refer to constitutional and rule of law giants in the field, such as Jan Werner Müller. He was, for example, one of the first scholars who proposed the existence of a Copenhagen Commission, so a separate entity overseeing the rule of law. I think it doesn't have to be Copenhagen, it can be a Rome Commission too, in order to emphasize that it's not just member states that more recently joined the European Union that might have rule of law issues, but certainly a separate entity would be very beneficial. And actually the European Parliament was already brainstorming in a 2016 resolution of how such a body could look like. I'm not saying that we have to follow their path, but at least there are some attempts, very, very serious attempts to put together such a commission. Of course, we can also borrow from other institutions, and we always emphasize that we don't have to reinvent the wheel. So whenever, so this commission or whichever entity could also borrow from other institutions such as the Venice Commission or Greco and so on. What is crucial, I think, is that it should have a European Union touch. So you cannot outsource entirely such an exercise, exactly because these international, other international entities, they are not entrusted with taking EU law specificities into consideration, such as the obligation of loyal cooperation or the obligation to mutually trust each other. So the Council of Europe, for example, cannot do this exercise. So these EU specificities should be taken into account by an EU institution. But I very much agree with Marcel. My preference would also be to have a separate entity entrusted with rule of law monitoring.
Alex, can I jump on this one and asking also Carolina to intervene? Carolina, would you agree that there is a tension between citizens asking for politicians making clear choices in policy areas, while at the same time not trusting politicians and then establishing agents with experts who have to do the policy making? Apply to not only competition, but for instance, rule of law.
Yeah, well, from the point of view of citizens, and what I find myself very interesting is the fact that citizens seems to distrust more and more politicians, but they like experts. So technocratic governments, perhaps because they know they will only last, 6 months or 8 months or a year, but it seems that citizens like the idea that you can build a body that has one specific function, that function is done by expert, perhaps bipartisans, experts, better if independent, and independent body from governments, national governments. It seems that citizens would appreciate these, but only if it's for limited amount of time, only for limited and very specific function, and it would be clear possibly to them what has been done, in what way. So this is strange, yeah, because usually from the point of view of citizens, what they should appreciate is accountability. So I elect someone and I can, punish or reward accordingly for the work that these politicians have done. But it's not always like this. It seems that decisions by experts are equally appreciated if they're just very specific and just for a specific amount of time.
Great, thank you.
And thanks to everyone. That is all the time that we have today. But I would like to thank, of course, our great audience as well as our speakers for another opportunity to discuss such pressing issues in the context of this webinar setting in the Reconnect webinar series. Please follow us on Twitter at ReConnectEU and visit our website at reconnect-europe.eu, where we will be sharing updates on upcoming webinars. From Stephen, Petra, Carolina, and myself, it's thank you and goodbye.
Bye.